Okay, Brad, why don't you go ahead and share your screen? I've had the privilege of being in federal court with Brad. It was the Robinson case, is that right?
That is right, yeah.
That's been a long time ago.
That was a long time. Let's see here. Can you see that?
Not yet.
Okay. How about that?
Nope.
All right, so I just hit the green share screen button, right?
The green share screen, and then it needs to be open on your screen. And then you select that and then press share.
It is open on my screen. I've got share screen. There it is right there. Okay. How
There we
about
go.
now?
Yeah, that's good.
All right, very good. All right. So I'm Brad Tilt, and I have been doing real estate related litigation in Utah for 24 years now. I mostly do title insurance defense work, so I am mostly working in the context of a construction lien to avoid them or to defeat them, invalidate them in any way that I can. But I also have, from time to time, represented contractors to prosecute those lien claims. So I think I have a fairly unique position and ability to bring some perspective because I have looked at these lien issues from both sides of the V, as it were. And so I'd like to share with you today a little bit about the nuts and bolts of a state construction registry and how that plays into your construction lien claims. We'll briefly go over some of the history and where the SCR started and where it is now, and physically where it is, and the relationship to how it correlates with the actual lien statutes themselves, and talk about some of the ways to best use the SCR, the State Construction Registry, to the benefit of your respective client. So historically, what we now know as construction liens or pre-construction liens used to be called mechanics liens. You still need to know the term mechanics lien, of course, because a lot of the case law would have come up with the term mechanics lien in it rather than a construction lien or a pre-construction lien. But ever since I was first involved in practicing law, the statute got tweaked and changed just about every year until finally in the 2000s and the early 2010s, we landed on the new construction lien and pre-construction lien nomenclature. And so that's how they are known now. And before I get too deep into this, I do want to say that I am honored to be a part of such a distinguished panel today, but with all due respect to the prior topics, I can see why Gene chose to put me last, because this is by far the most interesting topic to keep people motivated and captivated on a sunny Friday afternoon. So as fascinating as I might find all of this, it is very hyper technical, and I therefore encourage you to please ask your questions and comments in real time where they are in context with what we're talking about here, and that way you will get the most out of this. You'll be able to get out of it what you are interested in getting out of it. And if I could ask for Gene or Jeff just to watch the comment box and help me realize if there's a comment or a question, because once I get in the zone and get going, I just won't even notice it. But please feel free to interject with questions, comments, or observations about life. All right, so construction liens are strictly statutory creatures. They are created by the Utah statute. The legislature said decades ago as a policy matter that it was important to protect those who perform labor and provide services for the improvement of real property. And therefore, they created a special lien to secure payment for those folks who provide services, labor, and materials for construction and improvement on real property. And that is what we now know today as the construction lien. To further strengthen the efficacy of a construction lien, the legislature gave it a super priority. They are not subject to the normal race notice system, first in time, first in right. It's not just who records first. In fact, typically a construction lien won't be filed until long down the road in the construction process, after the loans go on and so forth, and long after the work has been started. But the legislature gave them a super priority, a relation back priority, even to a time when they were not of record in the county recorder's office. And we'll talk shortly about how that has changed over time and what that priority is now. Historically, the priority for a construction lien was based on first visible work on the property. And that was based on the legal fiction of, if somebody's out there and they've got their heavy equipment and they're digging and grading and going vertical with construction, those types of activity, as a matter of a legal fiction, put the world on notice. The statute assumed that there was construction going on, and therefore that there could be the possibility of a construction lien arising against that property. Even though there was no actual lien document yet, no actual lien recorded in the county recorder's office, you couldn't go and check for liens on the day the work started, but that is the date for when priority was measured. That off-record historical exception to the normal first in time, first in right race notice sort of construct for priority of a construction lien created confusion for title companies and problems for them to determine priority, for example, with construction loans in particular. A lot of times contractors might get started on a project before the construction loan financing got finished, and if they did that, and somebody didn't actually physically drive out there and check to make sure there was no visible work being done on the property, then you could have a priority problem where the bank ends up being primed later when a recording happens for a construction lien. They get primed by that. That also, the historical perspective also created problems for litigation purposes. It actually spawned a lot of litigation. There was, again, this problem of somebody not maybe going out to physically check whether there was visible work commenced on the property yet. But there was also the additional complication that case law over time said that certain work on the property, even though it was visible and on the property, may not count, nevertheless, for purposes of establishing priority. So things like grading and grubbing and site preparation clearly can sometimes be very large-scale visible work, but that was under the old case law not sufficient to put somebody on notice for purposes of a construction lien priority claim. So it made things difficult for ensuring title. It made things difficult for and expensive for litigation. And so in 2004, there were the title companies lobbied to obtain a change in the construction lien statutes. And what they created in 2004 is what is now known as the State Construction Registry, or the SCR. And that is an online registry. It's separate from the county recorder's office, not run by the county recorder. It's not recorded in the county records. It's a separate state-maintained database where various construction lien filings are made and maintained. And we'll talk about what those filings are. And that was created as a way to make objective what was previously a subjective question for construction lien priority. Instead of trying to figure out what was first turned dirt and whether it was turned dirt that was sufficient to establish a lien or not, the SCR now said X is the date for determining priority, specifically the filing of a certain notice in the state construction registry. You look for it, it's either there or it's not, and that is how you measure priority. In 2011, there was yet another change, large-scale change to the construction lien statutes. Title companies again, and this time with the support of the lending industry, managed to get past some provisions that allowed for priority of construction loans over construction liens based on the certain filings that could occur in the state construction registry, and we'll talk about those in just a few minutes here, but that's all part of sort of the background of why the how the state construction registry came about, and the sorts of things that it handles. The big part of which is to clear up priority issues, and the other main purpose and goal of the state construction registry is to provide a means for people involved on a project to be able to communicate with one another, know who is out there on the project, and be able to deal with potential payment issues before they come potential lien issues and muck up the title, and without ever having to hopefully go to litigation. So when you file in the state construction registry one of these notices we'll talk about, it gets automatically populated out to anyone else who is associated on that project, who else has filed anything on that project. And so if you're a sub or a supplier, the general is going to see your name, going to see your filing in the SCR, and they'll know you're in the payment stream, or they'll say, hey, who are you? And you can get that all figured out. So communication, decreasing claims, and providing some objective guidance on priority were the two big driving forces for the SCR. Then in 2012, the entire SCR system got completely revamped and renumbered. It had been at 38-1-1 of the Utah Code, and now it's at 38-1A-101 for privately owned construction projects, and 38-1B-101 for government-owned construction projects. So there's really been quite a tortured history of getting the SCR from where it started pre-2004 all the way up to where it is now in the 2012 and post-2012 statutes. So the key comparisons between the current provisions for the state construction registry in the 38-1A and 38-1B as compared to the pre-2012 versions, now there is express recognition for pre-construction services, service providers to have a lien. Previously, construction lien statutes simply said that that liens were available to anyone who performed construction service, and that was defined as providing any labor, material, or equipment for the purpose and during the process of constructing, altering, or repairing any improvement to real property. Now, and there were cases where pre-construction service providers were able to sustain lien claims and so forth, notwithstanding that language doesn't necessarily clearly reflect that intent on its face. But now, as the statute currently stands, we have two different systems. There is a whole system for construction liens, actually swinging a hammer and so forth, versus and a whole other section now that expressly provides and allows for liens for pre-construction service providers. And they are somewhat different. We'll talk about that. Again, the new version has changed the priority landscape. The old concept of first work on the property, what is commonly or colloquially referred to back then as the first turned dirt test. First turned dirt test is dead. That no longer matters for priority purposes. Now everything priority-wise is based on an objective online filing. You search that to determine priority. Again, the filing is there or it's not. So it's a clear, bright line test. Another big issue in the new versions of the statute are that construction lenders are now essentially able to buy their way to priority. As I talked about earlier, it used to be that you had to actually make sure before your construction loan closed that nobody started work on the property, because if they did, before you close and record your construction loan, you have a problem on priority. Now, under provisions we'll talk about in a few minutes here, construction lenders are essentially able to buy their priority, even if there are SCR filings that are on there prior to the closing of the construction loan. There's a way that lenders can get those paid and taken care of and moved out of the way, and have the priority moving forward as against any construction lien claims. It used to be that there were differences and distinction between requirements and timelines to perfect a lien based on whether the property was a residential property or non-residential property. Those distinctions have, for the most part, been abandoned. There are, whether it's residential or non-residential, no longer matters, except for in the context of, so for SCR purposes, for what we're going to talk about today, there's no difference. There's only a difference when it comes to actually filing the lien notice on residential properties. The content requirement for the lien notice might differ. And when you actually go then to foreclose a construction lien on residential property, there are additional forms that must be provided and served on the homeowner in certain circumstances in order to foreclose the lien on a real property, or on a residential property, excuse me. And finally, additional requirement, there is an additional requirement to file a notice of intent to obtain final completion on non-residential property. We'll get to that later and talk about what that is and when that needs to be done. The law still does distinguish, however, between governmental projects and non-governmental projects. And any construction project that's undertaken for the government, the state, school districts, so forth, those properties are not subject to construction liens, but these SCR filings that we will be talking about today are still significant because they are still required as conditions precedent to being able to enforce bond claims, enforce and preserve bond claims. So what is the SCR and where is it? Again, it's just an online database. There's the website there where the SCR is located. When you click on there, there's a place you can go and do a search. There's a public search functionality, or you can get an account, which I believe is free. So you can manage your own filings and projects and so forth. So again, it's totally separate from the county recorder system. It's maintained by somebody entirely different from the county recorder. It's just a statewide database. And the importance of it is that in order to be even able to record a construction lien or a pre-construction lien with the county recorder's office, eventually, if you needed to secure your payment and potentially foreclose to get paid for your client's work on real property, you have to first satisfy all of the requirements of the SCR, these following things that we're going to talk about today. So you can't even record a lien at the county recorder's office. You can't sue to foreclose a lien. Your lien rights are barred unless you have met the requirements of making the necessary filings at the appropriate time with the SCR. So it's hugely important. So the SCR is a tool that allows title companies and other interested parties to search for whether there are any potential lien issues on the property. You search for these notices we'll talk about. If there is no notice, if the property or the project doesn't flag, then you know that you're clear and you can move forward. You don't need to send somebody driving around the state to say, yeah, there was certain equipment out there, but I don't know if that was for grubbing or clearing the property, and that wouldn't count for lien, or whether that was something to start digging the footings and foundation, which does count for a lien. You know, you do away with those subjective tests, and you're able to make a determination on the spot. It allows construction and pre-construction professionals to file online to objectively preserve their rights. So it's a benefit to them as well, instead of having to play the guessing game. General contractors and owners of the property are notified of any filings on their project when they come in. Anyone that's claiming to be involved in the project. And again, all that's toward the underlying driving theory and purpose of the SCR to provide notice and encourage communication among all of the various parties that might be involved on a construction project, all toward the intended end of being able to resolve payment problems without liens and to resolve liens without having to file lawsuits. So now we start to get into what the filings are and the timelines for them. So through the rest of the materials I've highlighted, whenever there's a filing that, so here the first filing is a notice of commencement, and that's an easy way to flip through this later. By the way, I'm not sure if these materials from all the group are things that are just being emailed out to all the participants, but I'm happy to share my materials if folks want to have those for future reference. So just let me know about that. So previously, under the old construction lien statutes, parties were the owner or the general contractor on a project was required to file a notice of commencement before at a certain point in time early on in the project. And if a notice of commencement was not filed by the owner or the general, then none of the other notices that we're going to talk about here today were required. Nobody would have to deal with the SCR at all unless the owner or the general upfront filed a notice of commencement on the project. That has been changed. That is no longer the law. Now a notice of commencement is not required at all on any privately owned projects. So everyone involved on a project now, whether they're a sub or a supplier or the general or anybody who hopes to perfect and maintain a construction lien or a pre-construction lien to preserve and collateralize their payment prospects, everyone must file with the SCR the notice of retention, which we'll talk about shortly, or a preliminary notice, which we'll talk about shortly. So don't bother looking for a notice of commencement and say, oh good, there's none there and I therefore don't have to make my filings, because that's not how it works anymore. Yeah, so as of 2011. Okay, so for pre-construction service providers, they file what is called a notice of pre-construction service. And I've got the statutory site for where that goes. It used to be called a notice of retention for people who might be more familiar with that, the old verbiage, but it's now a notice of pre-construction service. So that would be any planning or design professional, architects, engineers, and so forth. They must file that timely with the SCR in order to preserve any right or ability to later record a pre-construction lien with the county recorder's office. And for the notice of pre-construction service, those service providers must file that notice with the SCR within 20 days of the date that specific pre-construction service provider started their work. So the day the architect starts his work, he's got 20 days to file with the SCR his notice of pre-construction service. Same with the engineer, that he's got 20 days after the day that the engineer starts his work in order to file his notice of pre-construction service in order to preserve potential lien rights. There is no quarter for any late notices of pre-construction service. Anyone who fails to timely file their notice of pre-construction service, quote, may not claim a valid pre-construction lien, end quote, period. That's it. And those pre-construction service liens, notices, they get recorded, filed with the SCR anytime there's a, quote, anticipated improvement to the property. So better safe than not. Go ahead and file those, get them get them on file. Notwithstanding that each respective pre-construction service provider must file within 20 days of their own date of first work, they all end up being on equal footing. All pre-construction service liens lien claimants who file a timely notice of pre-construction service will have the same priority of their lien as all of the other pre-construction service providers. They're all on equal footing once they have made a timely filing with the SCR. If they do get to the point of actually recording and prosecuting a lien, they share equal footing priority. That was not so originally, but that's been the case for a number of years now. So that is another change. Pre-construction service liens, however, are in any event subordinate to construction loans that may come along later, to the extent that the pre-construction services were provided after the recording in the county recorder's office of a bona fide mortgage or trust deed. So if you have a bona fide actual construction loan that comes along later, work that is provided by pre-construction service lien claimants will prime that loan only to the extent that work was performed before the construction loan went on. That was another benefit that the loan industry was able to negotiate into the changes that we talked about in the statutory history. Construction service liens then. A construction service lien claimant, someone who's running a machine or swinging a hammer out there, asked to file with the SCR a preliminary notice in order to preserve and potentially eventually perfect and enforce any lien rights. Those preliminary notices by construction service lien claimants must be filed within 20 days of each respective construction service provider's first date of work. If that happens, if they timely file that pre-construction notice with the SCR within 20 days of their own first work, then that notice is sufficient to retroactively cover days 1 through 19. If they file that on day 20, any work they performed in the preceding time will be protected and preserved as far as lien rights go. Late preliminary notices are allowed under the SCR. Remember, a notice of pre-construction service, if you're late, you're out. But on a preliminary notice for a construction lien, you are allowed to file with the SCR after that 20-day window. But your preliminary notice does not become effective to preserve your lien rights for another 5 days after the date you file it. So if you file it on day 21, and so that's untimely, you didn't meet your 20 days, it doesn't kick in to perfect your potential lien rights until day 26. So all of your work on day 25 all the way back through day 1 is no longer protectable as a part of your lien if you ever had to record a lien and prosecute a lien claim later. So so it's important to get those in timely still, but there is at least a saving grace where you can protect and preserve some of your clients' work moving forward. But if there is no preliminary notice recorded at all by a construction service lien claimant, then they have no ability at all to record with the county recorder's office later a construction lien on the property. It's important, sometimes clients don't realize that they still nevertheless may have a contract claim for collection of the money that's owed to them, even if they miss those pre-construction notice deadlines or the preliminary notice deadlines. Even if they're barred from a lien claim, it's important to remember your client still may have a contract right for a money judgment to recover the value of its work. Just no lien right for it, just no collateral, just no leverage. And I have found that that becomes especially important for smaller subcontractors and suppliers, because they often are not the best bookkeepers, and they often don't insist on getting contracts written or even more so getting signed. And you want to avoid being in a posture of having a small sub or supplier out there who doesn't have a written contract, and then they lose their lien rights under these provisions, because then they're in a posture of potentially being barred from any remedy. Their quasi-contract remedies or their equitable unjust enrichment type remedies might be barred for failure to exhaust it remedies. The construction lien statutes are an available legal remedy, and if those dates and deadlines are missed and your client does not have a written contract, they might be in really bad shape. So again, it's very important to watch these dates and deadlines and hit them.
Brad,
Yeah.
how does this relate to the lien recovery fund?
Same thing. If you, the lien recovery fund, so they would have an ability to claim against the fund to get payment out of the fund.
Yes.
Yeah, I honestly don't know how that works. I do not believe that the SCR plays into that, but it would not. I've not seen it or dealt with it, but it wouldn't surprise me if something was there. I would think the fund would say, "Hey, why should we have to pay out if homeowners can get off the hook from homeowners and building owners can get off the hook for non-compliance? Shouldn't this be a way to require them to preserve the solvency of the fund?" So the short answer is I don't know, but if anybody else has any insight on that, I'm certainly open to it. Anybody?
Yeah, Brad,
Yeah.
if a contractor doesn't file a preliminary notice preserving their lien rights with the state construction registry, then my understanding is they have no recourse with the Utah Lien Recovery Fund. They have to be able to show that they filed a preliminary notice.
Yeah, that doesn't shock me. Okay, very good. Thank you. All right. So priority, just like with the pre-construction liens, all of the construction liens will share on equal footing as of the date of the filing of the first preliminary notice with the SCR. So everyone has to meet their own date or deadline to timely file their notice. But once they've done that, the priority for everybody in the construction lien class will be on equal footing as of the date of the first timely recording of any preliminary notice with the SCR.
And all of
There's
this
also-
is after the mortgage company files their notice.
Well, so we don't know. I mean, if there's, I guess that's actually a nice lead into the next section here. We start to talk about the lenders. So the short answer is, so you have all your, let's say there's 6 or 8 or however many there are preliminary notices that are on file with the SCR for potential construction lien claimants. Then the construction loan comes along and the lender pulls the SCR filings, and they see those filings there. This is how they can buy priority now. It used to be that you're just out of luck. There was no way to deal with that. Whatever the priority was under the Turn Dirt statute, that never could change. But now the SCR allows the construction loan lender to pay off all of the work that has been done up to the time of the recording of the construction loan, and all of that work goes away. All of the lien rights for that work goes away, and then those contractors have to make new preliminary notice filings in order to preserve their lien rights moving forward for their future work, but that would then be junior to the construction loan. So on the one hand, that maybe puts shifts the risk a little bit from the lenders to the construction lien claimants as far as ongoing or future work goes, but it also does give them a tool to at least collect on some of their early work up front before the construction loan even goes on. So that raises another question that I wanted to maybe throw out to the group at the end that people can be thinking about, is whether this whole scheme is a good one or not, and whether it's been successful in achieving its desired ends of decreasing liens and litigation. All right, so the next potential notice that could be filed is a notice of a construction loan. A construction loan lender, it says, shall file a notice of a construction loan with the SCR, quote, promptly after recording the mortgage or trust deed with the county recorder. They also are required to, they quote, shall file a loan default notice with the SCR within 5 business days after recording a notice of default with the county recorder's office. But it's curious that the statute in both instances says that those items shall be filed. They're required. You've got to do them. And under the one, you have to do it promptly, whatever that means. But there's no teeth in the SCR statutes currently. There's no consequence for not filing one. So it's interesting that they use that verbiage but don't put any teeth behind it. And so that raises the question I posed there of what are the consequences. It seems those particular provisions seem superfluous in my view. But then we get to this provision where I was just talking about a minute ago about buying priority. A recorded mortgage or trust deed that secures a construction loan attaches immediately before the first preliminary notice filing for the construction project if each lien claimant that has a preliminary notice on file with the construction project before the mortgage or trust deed was recorded, if they receive full payment for all construction work and that the claimant performed before the mortgage or trust deed recorded, regardless of whether the claimant receives full payment before or after the date on which the mortgage or trust deed is recorded. So I think that's actually a bit of a change from what I was saying before. I'm not sure whether they do need to file new preliminary notices after that or not. I would have to double check that. But in any event, the point is they can close the construction loan and the lien claimants can be paid for their work that occurred prior to the recording of the construction loan. And that way the lender can, by that means, buy their way to priority. And it doesn't matter whether they do that before or after the construction loan closes. So that is, again, a pretty big shift in the paradigm and the shift of the potential risks. The next potential notice is a notice of completion. That is something that can be filed by an owner, a general, a lender, financing the project, a surety, bonding the project, or a title company issuing a title policy on the property. And it may be filed, quote, upon final completion, which is a 3-part test under the statute. If it's a project that requires a certificate of occupancy, then the issuance of the CO is the date for that there is final completion. If there is no CO required, then the date of the final inspection is the date of final completion. And if there's neither of those required, then it's the date that there is no substantial work yet to be completed, or the date that no funds are any longer being withheld by the owner for any reason. On a commercial, let's see. Yeah, on commercial projects only that are in excess of $500,000 or 120 days, and where there is no payment bond, then there is also a notice of intent to file a notice of completion that is required as well. And if there is anyone who is not yet paid at the time the notice of intent to file a notice of completion gets filed with the SCR, they then file a remaining to complete notice where they say, they update and amend their preliminary notice, and they say, here's how much work, here's who I contracted with and how much I'm owed and how much work I have yet to be completed and so forth. All again to the point of trying to communicate and make sure everybody knows who all the players are and avoid some payment issues later.
Is there, Brad, is there a requirement to be licensed in order to file these notices?
I have not looked specifically at that, but I would imagine there is. You have to be licensed in order to claim the lien eventually. So even if it doesn't specifically say in the SCR statutes that you need to be licensed to do the SCR filings, it's kind of superfluous to do them if you're not licensed and you can't enforce a lien anyway. There are provisions as well in the SCR to prevent abuse. Anyone who files a notice with the SCR without a good faith basis for doing so, or with the intent to extract more than is due, or to procure any unjustified advantage or benefit, is guilty of abuse of the SCR, and they can be held liable to the owner of the construction project, an original contractor, a sub, or any interested party who is adversely affected. There's a for actual damages or $2,000, whichever is greater. The party filing any particular notice bears the burden of proof to sustain it in the event of any challenge to it as being an abuse of the SCR. And parties may contest notices, any of those notices we've talked about, as lacking a proper basis and is therefore being invalid. And they may request from the filing party evidence of establishing the validity of the notice, which the filing party is required to provide, or they are required to cancel their notice within 10 days. So again, this is a way for everybody to learn who's out there on the project. And if a general or an owner says, I don't know who you are, they can use these provisions to have that person who has filed something with the SCR, prove up their notice or remove it, and thereby avoid some lien claims and litigations. Wanted to just touch briefly then on the actual lien provisions that then come up. So if you successfully navigate the SCR landscape, which you have to do before you can record any lien with the county recorder's office, then you still have to do that. You still have to go ahead and record your lien with the county recorder's office. You can't do that without satisfying the SCR, and the SCR is not itself a lien and hasn't created a lien yet. So you've got to do both. You've got to record a statutorily compliant notice of lien with the county recorder for pre-construction service lien providers. That has to be done within 90 days of completing their pre-construction services and not being paid. And at the outside, pre-construction services are deemed to have ended once construction services start. Construction lien claimants also have 90 days to record their lien if there is a notice of completion filed with the SCR. That was one of the notices we talked about just on one of the last prior pages there. If there is no notice of completion filed with the SCR, however, then construction lien claimants have up to 180 days after final completion, that three-part test we talked about, in order to then record their actual lien document with the county recorder's office. So as a general who's trying to make your owner happy, you may want to make sure you get your notice of completion filed, because that's going to cut in half the number of days that the property is out there and subject to potential liens getting recorded on it. If you're the owner, you certainly want to do that. If you're somebody wanting to cut off some lien rights, you want to look for and make sure there is filed a notice of completion with the SCR to cut that lien time down. Then there's the certified mailing requirement. The lien that gets recorded with the county recorder's office has to be mailed out and so forth under the lien statute, separate from the SCR provisions. And enforcement of the lien has to come next. So you have to first meet all the SCR requirements, then you have to create a valid lien, and then you still have to enforce it, or everything else is for naught. The lien enforcement action, a lawsuit, has to be filed within 180 days of the recording of the notice, of the filing of the notice, of 180 days of the recording of the notice of lien with the county. So once you get to that point and you've recorded with the county, you've got 180 days to then file your lawsuit to foreclose it. During that same 180 days, you also have to serve that lawsuit on the defendants, or record a lis pendens in the office of the county recorder to give notice of that lawsuit. Anyone who is not named and served as a party to your lien foreclosure lawsuit will not be subject to the lien or any enforcement action on that lien unless you have recorded a lis pendens with the county recorder. That, as you know, gives notice to the world of whatever the contents of that document are. That therefore gives notice to the world of the existence of your lien foreclosure lawsuit. So always best practices to get your lien filed, get your lawsuit filed, and immediately record a lis pendens. And then if you have to amend to add more people in, you can do that, and they're going to be subject to it, and you don't have to worry about serving, not having served them and having them have a potential escape route. For liens on residential property, this is one of the remaining distinctions between residential and commercial. When you serve your lawsuit to foreclose, you also must serve with the summons and complaint a certain statutorily specified notice of rights under and forms for exercising rights under the Lien Restriction and Lien Recovery Fund Act. Essentially, those forms inform the homeowner that they can evade lien actions and avoid potential double payments, essentially, if they can prove that they had a written contract with a licensed contractor that they paid in full. And if that three-part test can be made, if they can prove that up to the Lien Recovery Fund by filing the forms that are served on them with the summons and complaint, then that particular contractor and that particular lien goes away, but so too does any potential liability that that property or that owner might otherwise have had for any other lien of any other contractor on the property. The theory being the owner's already paid the contractor once, and it's the contractor's fault that he didn't pay other folks. We shouldn't have the owner have to get dinged twice for those same improvements. So that's a tool for homeowners to be able to use. There also is a release of lien and substitution of alternate security statute. I've copied a big chunk of it into the materials here, and you can see that there was only one change in this last legislative session, changing from 90 to 180 days, the time for filing the paperwork under this. Property owners can submit for recording at the county recorder's office a notice of substitution of alternate security, and thereby free up their real property from the lien, and that lien then attaches to the alternate security. The alternate security has to be a bond or cash equivalent, as is outlined in the statute here. There are certain amount thresholds that have to be met, and certain bond rate requirements that have to be met, and all that technical stuff is in the statute there. But if that document gets recorded with the county recorder's office, automatically the lien gets released, just by operation of law from the real property. It attaches instead to the alternate securities, and parties have to then amend their pleadings in the lawsuit and attach the alternate security and pursue the alternate security instead of the property. So that's an important tool for homeowners to be aware of. The latest on the SCR, it used to be that the construction lien statutes got changed, about every year. I started practicing in '96, and every time I thought, hey, I finally got this issue or that issue under this statute mastered, then inevitably it would be changed in the next session, which frustrated me as a baby lawyer. But then I realized it was a Full Employment Act sort of a situation, so I got over that. But they really did tinker with the construction lien statutes almost yearly, all the way up until 2004, and there really were a lot of changes as well, almost yearly, up until 2012, when we talked about earlier, the whole system for the SCR got completely revamped and renumbered, and all these provisions were put in place for the objective priority and so forth. And honestly, since then, they have remained largely static. There have not been a whole lot of amendments to the construction statute since that time. Two that did come up this past session, though, are this section 38(1)A 603 that deals with a notice of intent to finance, where owners may file an intent to finance on their property, and there's a provision 604 for notice of a final lien waiver in the event that a notice of intent to finance gets filed. I I don't know what the legislature was thinking with that. There's a provision at the end, subsection 4 there, that says if a notice of intent to finance is there for more than 30 days and they don't actually finance, then that notice of intent to finance has no effect. But I don't see anywhere where they ever spelled out what the effect of a intent to finance filing might be. If anyone else has some insight on that, I'm open to it, but all I can think is that they were thinking something, getting something filed with the SCR for notice purpose, so people who were on the project could say, oh, there's a loan coming, I got to get my docs in order, maybe I'm going to get paid off here. Beyond that, I just really don't know what the notice of intent to finance would do or what effect it might have. And the notice of final lien waiver provision says, well, people can waive their lien rights within X number of days of a notice of intent to finance. But then it says, you can also file a lien waiver at any other time if you want to. So I'm not entirely sure what that was designed to get at or what benefit it serves. But those were the only two changes this last session. So kind of the big picture takeaways for the SCR are: remember to timely file those notice of pre-construction services liens, because a failure to do so is absolutely fatal. You miss your 20-day window, there is no saving. You're just out. Failure to file any preliminary notice on a construction lien claim also is fatal, but you can file a late one. If you miss your 20-day window, it just won't become effective for another 5 days, but it's still important to get it in there if you still have a lot of ongoing work to be done. You want to protect your lien rights for that. As far as tips for using the SCR, you'll find if you go to that website, you click on there, it's fairly easy to navigate around. It has big buttons for you to push if you're a contractor or a sub or a supplier or an owner, whoever you are on the project. It sort of has pages that are built for you to be able to click through and find what you need to find. The important thing that I would suggest when you get in there and you're running searches on it, since the SCR is foundational to be able to have any lien claim later, you've got to get your filings made with the SCR. The most important thing that I can suggest is there are a number of different ways that you can search for a project: by address, by tax ID number, by legal description, by owner, by contractor involved, and so forth. I would suggest using every possible search metric, and I would also suggest using every possible variant of every possible name. If it's with or without variant spellings of Taylor or what have you, OR or ER. Search every conceivable way so that you are sure that you have found what there is to find, and that if you don't find something, you're sure that's because there is nothing, because you don't want to say, I've not filed anything on this project, or I've missed some deadline because I couldn't find it. Those are my comments, and I welcome any questions, comments, observations about life that anybody might have for our final minutes.
This is interesting and refreshing to see what the changes have been